Okay, we'll go ahead and get started. Good evening and welcome to another Spotlight PA live event hosted by Spotlight PA. I'm Christopher Baxter, the Executive Director and Editor-in-Chief of Spotlight PA, and I'm so glad to see everyone who's joining us here this evening and thankful for the time of our panelists as well. The issues surrounding aging, guardianship, and protecting vulnerable folks from abuse in Pennsylvania are extensive and complicated, and I'm proud that Spotlight PA is hosting this discussion tonight as a jumping off point and a continuation of our work in this area. For those of you who are new to our programming, Spotlight PA is an independent, nonpartisan, nonprofit newsroom producing investigative and public service journalism about the state government and urgent statewide issues. We make all of our vital reporting available to the public at no cost through our website, spotlightpa.org, as well as sharing it with 94 community newsrooms who republish our work all across the state. And we can only do that because of your support. Tonight, we're at a pivotal moment. We have about just 48 hours left in our spring member drive. We're right down to the wire. It ends midnight Saturday. And we have about $9,500 more to raise to hit our goal and keep our work going, including programming like this. So tonight, we really do need your help more so than normal to get to that goal. As a special bonus, every gift tonight will be matched dollar for dollar. That means your gift now will be doubled. Please take a moment right now and go to spotlightpa.org/donate and make a gift in support of our work and in support of events like this. While you do that, I want to pause here just to emphasize why this model of public access to information is so important to us. In January, a woman reached out to me to say that she couldn't support Spotlight PA this year. She had given $5 last year, a very small amount, but all she could muster, and every dollar counts. But this year, she simply couldn't afford it. Access to vital information, the facts you need to cast an informed vote or to hold your elected officials accountable, should not depend on what you can afford. And that reader should not lose access to vital reporting just because she can't afford to chip in this year. That's why we feel free public access to civic information is so vital. And that's why we need you tonight. We don't charge a subscription fee and we don't have a paywall, but we do depend on the generous support of those who have the means to allow us to continue this public service work. So I'm going to ask one more time for folks to please go to spotlightpa.org/donate now to make a gift. Once again, every dollar you give tonight will be doubled. If you're already a member, I want to say thank you, thank you, thank you for your support. You are making this work possible, and we couldn't do it without you. A few housekeeping things. We are recording today's event for those who can't make it. You can view the event tomorrow on our website. We'll upload it and let folks know when that's ready. If you have a question for our panelists tonight, please drop them into the Q&A section of Zoom. If you just look down on the toolbar there, there's a Q&A button, click that, type it in, and we'll get to as many of those as possible. We know many of you have submitted questions in advance, and likewise, we will get to as many of those as we possibly can. And with that, I'm going to hand it off to Spotlight PA's Angela Columbus for tonight's panel. Angela?
Hi, welcome everyone, and thank you so much for joining us today to talk about this very important issue. I personally didn't understand quite how urgent an issue it is and how many people's lives it impacts until I wrote a story for Spotlight in late March about a long-running court battle involving a guardian revealed just some of the problems that exist in Pennsylvania's system for protecting incapacitated adults. One staggering statistic I learned during the reporting, the state has over 18,000 active guardianships, nearly half of which involve people over the age of 60, and those guardians oversee more than $1.7 billion in assets. After the story was published, I heard from dozens of people, many of whom have had very difficult and painful experiences with the guardianship system, and who believe more often than not that the system is rigged against them and their loved ones and ultimately set up to financially benefit many of the professionals involved in it. So we decided to hold this webinar in the hopes of bringing some more attention to the issue. Just a few notes about the format. I will be asking questions of our panelists for the first part, and then asking some of the questions that many of you in the audience submitted ahead of time, and thank you for that. I won't be able to ask them all, but please know that you can always reach out to me afterwards. We will be dropping my contact information in the chat. I'm continuing reporting on this story and would be happy to speak to any of you. You're also welcome, like Chris said, to put some questions in the chat or Q&A throughout this webinar. But again, given our time constraints, I can't guarantee that we're going to get to all of them. So with that behind us, I'd like to introduce our panelists. We have State Senator Art Haywood, who represents parts of Philadelphia and Montgomery counties. We have Stephen Feldman, a leading lawyer and authority on issues involving elder law and healthcare, and Dr. Tina Paone, a professor at Monmouth University. She's a professor of education and counseling and leadership. Thank you, all three of you, for being on this panel. And I'd like to start by asking each of you to give our audience a brief introduction and tell us how you came to be involved with a guardianship system. We can start with you, Stephen.
So I graduated law school in 1981 and became the executive director of this, what is now the Senior Law Center, which is a free legal service program for the elderly in Philadelphia, actually in Pennsylvania with their statewide hotline. But before that, I worked at the Philadelphia Geriatric Center in their behavioral research department, where I worked with the elderly who were suffering from some forms of dementia. And then I went into private practice and used my background in aging and my legal background at the Senior Law Center to establish a practice focusing on long-term care issues and planning for the elderly.
Great, thank you. Senator, I'm going to turn it over to you now.
Sure. State Senator Art Haywood. A neighbor of mine was a victim of a crook, Gloria Byers, who ended up taking significant money and property from them. And my neighbors reported it to me. Wasn't able to do anything to stop it at the time, but we were able to work with other members of the General Assembly, particularly the State Senate, to develop legislation that we believe will help protect individuals going forward.
Great, and we're going to talk more about that in the next 20 minutes here or so. But before that, Dr. Paone, if you could also tell us about your experience with the system and a little bit about yourself.
Sure. As you've already introduced, I am a full professor at Monmouth University and a licensed professional counselor. I do have personal experience with guardianship abuse in the state of Pennsylvania, and I was able to speak on behalf of victims nationwide at the United States Special Senate Committee on Aging this past March. I got involved in the guardianship system in January of 2015 when my 68-year-old mother had a major stroke, which left her incapacitated. My brother and I petitioned the court for emergency guardianship to assist with her medical care, her rehabilitation, housing, and finances. And I know we'll get more into that as we move forward.
Thank you. So I'm going to throw the first question out to you, Stephen, just for those who may not know, although I believe many in our audience do, who may not know much about the issue of guardianship. Can you talk about the concept of it in Pennsylvania, what it is, who does it affect, and how does it work, and some of the responsibilities that a guardian takes on?
So guardianship in Pennsylvania, as well as throughout the country, is a system which has been developed by legislatures across the country and applied by the courts to, is basically a system of surrogate decision making. So if you have an individual who, for whatever reason, medical, psychological, can't make decisions for themselves and their capacity has become impaired to some extent, there is a need to make decisions on behalf of that person. So guardianship is one system of surrogate decision making which applies substituted decision-making. The court hears the issues, submitted to them to determine whether an individual is incapacitated. And if the individual is incapacitated, how best to provide for the surrogate decision-making to protect the individual's person and his or her property. And so that's the system we have in place now. There's actually two systems of decision-making. One is administered under the Pennsylvania States and Fiduciaries Code, and the other is a separate system, which is administered by the Department of Aging to provide adult protective services, both of which are both different surrogate decision-making systems.
And just to follow up on that, I mean, can you talk about professional guardianships or guardians actually, and their role in the guardianship ecosystem? And should they be appointed in cases where an incapacitated person has family or friends who could step in to perform the same functions? And I ask this because many of the people who have contacted me have sort of described these nightmarish dealings with court-appointed professional guardians. And in some cases, the end result has been that they've been barred from seeing their loved one. So if you can talk a little bit again about professional guardians and their role in the system.
Well, the PEF code has a section on guardianship support agencies, and it's one of the things that Senator Haywood's piece of legislation that he's sponsoring is addressing. Right now, there's no certification for these guardianship support agencies or what are called professional guardians. And so there's going to become a requirement to become certified, and that the standard of certification is to be set by the Supreme Court. In answer to the other part of your question, should a professional guardian be appointed when there are other family members? And the answer to that is it depends. Oftentimes family members fight over their parents and their parents' property. And so appointing one over the other without some significant justification becomes more difficult. And there are those individuals who simply don't have family members. They're unbefriended, what I call the unbefriended elderly. They have no close family members, or they've been, alienated from their family. So in those cases, somebody has to make the decisions. Now, it may be that there's not a need for, a very intrusive, overpowering order to take care of everything for this person. Person might not need help with everything. So the law requires the least restrictive alternative under current law. They're under the piece of legislation that Senator Haywood is sponsoring. They're trying to strengthen that. In my experience, I think that the courts often overprotect. They err on the side of overprotection for a variety of different reasons. But when you hear these nightmares that you're going to probably get specifically into, the courts don't want to appoint a guardian over someone who doesn't need it. They certainly don't want to appoint somebody who's not doing their job or ripping off the elderly. So, they don't have complete control over it once it's, the system is in place. But there are annual reporting requirements that, guardians have to comply with. So in answer to you, the short answer is, if there's caring family members involved, there should not be a great, need for guardianship services unless there's, a complicated large estate. Banking has to be done. People need legal authority to administer another person's estate. But again, I mean, there's ways to plan ahead of time to avoid the need for guardianship.
Yes, and we'll definitely get into that a little later in the panel. But I wanted to throw it back to you, Dr. Paone. In your case, I mean, if you can maybe expound a little bit more about your case with your mom. You had a good relationship with your sibling, and yet you found yourself in this situation. Can you talk a little bit more about that experience to the extent that you are comfortable doing so? And what aspects kind of surprised or concerned you as you went through the process?
Right. So in a nutshell, our experience has been awful. I have not spoken to another person who has said they've had a positive experience with our guardianship system here in Pennsylvania. My experience has been that discovering that our court system, specifically our guardianship system, is a system designed to target marginalized population of individuals, specifically our elderly and our incapacitated people. What surprised me? I didn't realize the amount of nepotism, the violation of the law, the power-hungry, greed-driven individuals involved in the system. Though I don't have a lot of time to talk about all the details of my experience, I do encourage anyone listening today to just jump over to the United States Senate Special Committee on Aging and review my full testimony, which really covers all of the horrifying experiences that we've encountered. It will definitely ring a bell to majority of the folks. I see the chat coming in through our discussion, and it is the same things over and over. So there's not a lot of doubt that you will find a lot of a connection to your own experience. Not exactly the same, but a lot of the same horrifying experiences. I was surprised that we have a Pennsylvania bench book for the Orphans Court, but what actually happens in the courtrooms looks very different. I was surprised that the very same people saying that they're advocates for incapacitated people and our elderly that need a guardianship are the same people that are perpetuating injustice against them. What concerned me about the courts is that there's no recourse for families of loved ones who experience abuse through the guardianship system. There's no repercussions for negligence of court-appointed attorneys or court-appointed guardians. The support that's provided to court-appointed attorneys and court-appointed guardians is rarely in the interest of the actual incapacitated person. Guardianship abuse is not addressed when it's involving court-appointed attorneys and court-appointed guardians. That has been my experience. Very costly on the end of loved ones trying to remove their family members from these restrictive components. Once you're in the guardianship system, it is difficult to remove these court-appointed attorneys and guardians from these roles. My experience personally is that my brother and I are on the same page. We have been on the same page since day one. We have always worked together. We continue to work together. We have spent since 2015, and our case continues to be unresolved. My case isn't uncommon when you look at other folks across the state of Pennsylvania and the United States in general. The guardianship abuse system, and I call it a guardianship abuse system, not the guardianship system. The abuse within the system needs to be addressed from many different angles. So that has been my experience. I hope that's answering your question.
Yeah, yes, it does. And I have a quick follow-up to you before I asked the senator to weigh in on this, on his legislation. Given everything that you've said, what would you like to see, speaking as somebody who's had experience in the system, in a bill, and can a legislation address some of these issues?
So I can speak to only viewing the federal bill and the state bills that have been proposed, but there seems to be a disconnect. For example, the federal bill indicates that there will be reviews of guardianship every year. The state bill doesn't address this. The federal bill also indicates that there will be guaranteed procedures for modification or discontinuation of guardianships into less restrictive arrangements when appropriate. But the state bill doesn't address this. Further, there's an indication that the federal bill states that they will investigate incidents of guardianship abuse at the state level. This isn't mentioned. This state bill honestly doesn't look at what would help someone already in the system. It may help someone being considered as an incapacitated person, the arrangements to look at alternatives or less restrictive before they're put into guardianship, but it doesn't address what happens once a family is already stuck here.
May I respond to some of what you said?
Yes.
No system is perfect, but I would respectfully disagree with most of the way you've described this system. And even though there are shortcomings, there are certainly sufficient procedural safeguards and certainly remedies available to address some of these concerns that you've raised. Now, I have no idea, I have no familiarity with your case, but the court can be petitioned at any time to review a guardianship. And any of the matters that you've suggested occur can certainly be brought to the court's attention. And I can assure you that a court will certainly at least listen to the concerns that are raised. How they are addressed, I don't know. I'm not familiar with your case. So, but I will assure you that there's a lot of remedies available to address some of these issues, including, the imposition of a guardianship where it may not be necessary in the first place.
Yeah, and one of the, we've had several audience questions actually about that precise issue, ending a guardianship once it started. But before we get there, I did want to have the senator talk about his guardianship bill and how it attempts to address some of the problems in the system. Senator?
Yeah, thank you so much for all the comments. So I think the characterization that the current legislation primarily addresses entry into the system is accurate. We had the professional certification requirements to increase the professionalization of those who are guardians, the professional guardians, certification requirements, legal representation requirements, and those are all around entry. We do have some new requirements to make it more likely that a judge would choose a family member. It requires a judge to demonstrate that they've gone with the less restrictive alternative. On the exit side, though, I will say that through the testimony that we've heard at the hearings, that we are developing some exit provisions, and the exit provisions will be in an amendment to the guardianship law that we will probably have in the Judiciary Committee next week or the week thereafter. And the exit provisions that we are looking at to amend the current provisions will follow some of what was described in terms of the federal approach. When the bill is done, I believe we will have dealt with some improvements on the entry side, as well as some improvements on the exit side. But that amendment we don't have to share, it's not done. Both entry and exit are serious issues.
Just a quick follow-up on that, Senator. One of the complaints I've heard over and over again is that people dealing with the guardianship system feel like they're just getting swallowed up, and that the system doesn't exist to help them. It exists to help, professionals involved in it financially. And I'm wondering what your response to that is, and if there is any way you think legislation could even attempt to address that kind of feeling, whether true or not. I'm just going to throw that back at you.
Yeah, I think the main way will be on the level of exit, so that people don't feel that they're in forever and can't get out. So I think we can have some stronger exit provisions, which we're working on, that will help. In terms of system corruption, which I hear, I said some of the chat, is system corruption. So the system corruption is a more challenging thing because it's the courts oversee the system, and there's not another group of people that would be in a real position to oversee what the courts are doing. So I think we do need to take another look at the system corruption issues. Obviously, allegations that the judges are corrupt is a very serious one that will require a significant amount of investigation. But judge corruption obviously goes, unfortunately, potentially well beyond guardianship if that's exactly what we're dealing with.
And Stephen, I want to throw that back to you too, because you've had quite a bit of experience in the system and some of the problems with it. What's your sense of that?
So first of all, the system is not there to help family members per se. It's there to help the alleged incapacitated person. So sometimes decisions are made by the court based upon the evidence that this individual needs protection. And it may be the case that the individual needs protection from the individual who may be another family member. You know, I've seen a lot of cases where family members do things to their parents that they're not supposed to. And there's a need for somebody to become involved. With respect to corrupt judges, and I don't know what county Dr. Paone is talking about, but in my 40 years of experience, and I've appeared in many of the counties, at least throughout the Delaware Valley area, I've never appeared in front of a corrupt judge. That is not to say that I've been happy with some of the decisions that the judges have made, but these decisions are reviewable. And for the most part, the system works. Doesn't work perfectly. And there's no doubt in my mind that people are subjected to guardianship when they don't need to be. But in those cases that I have become involved in and I'm aware of, the system, the judges corrected pretty promptly.
Mm.
So again,
Well-
I don't know what Dr. Payone's situation is at all, but that's not my experience in 40 years with the system. There are cases that are notorious, but they're notorious because there's so few of them.
And I would beg to, to have you take some time and do some, and again, I realize you have a full-time job and you don't have time to investigate some of this. It's not specific to me, my county, and my judge. This is a nationwide issue. I cannot tell you how many victims have approached me with this same situation. So perhaps what you are seeing from the legal standpoint and from a lawyer perspective is you have an ongoing relationship with judges, albeit a professional one. Families are unheard by judges. They will not even listen to what we have to say. So, corruption of judges is such a large and a very big accusation, but guardianship abuse by professional guardians and professional attorneys is absolutely there is a connection, there is an intertwining, there are key players, and I understand networking and how it works. My mom alone has spent over $116,000 specifically on court-appointed people that she didn't need. And I know she's not alone. And to some folks, that's not a lot of money. To our family and to my mother, that could have resulted in over a year of her care. Now she doesn't have that because she paid folks that didn't need to be put in her space to begin with. And again, Steve, I hear where you're coming from legally and professionally, but being in this space as an actual family victim and watching what's happening to my mother, it's horrid. It's not helping her. So these folks that are put into place to assist her are assisting each other. In our case, we had a court-appointed attorney that resulted in over $100,000 of negligence. And what did a court-appointed professional guardian that did that? The court-appointed attorney supported the guardian. The guardian wasn't revoked. The guardian resigned after many petitions on our behalf, but not because it wasn't available to her. As you said, you can look at the docket and you can find the information about these individual cases. It is very frustrating to hear that you're not seeing this happening anywhere, that anywhere in the Delaware Valley, that all our judges are on the up and up. They're not. And that is very unfortunate, because it would be really helpful if someone at the Senior Law Advocate Center where you're at would help our elderly in this respect. And unfortunately, I know myself and many of the victims who have contacted me have said that they can't find help available at that facility.
Well, I want to interrupt for a second and ask a question that has come up in many of the audience questions, and I think it's a little bit at the heart of this disagreement, and I wanted to throw the question to all of you, and we can start with you, Stephen. What I hear is that it's ending guardianship is a very difficult process, particularly when it involves the elderly. And one expert I spoke to told me that really guardianship for that population ends with the person's passing. So I wanted to throw that to you, Stephen, is it indeed really difficult in your experience to end a guardianship if you're a family member of an incapacitated adult?
So
Or at
again,
least
there's
change the
gonna be-
terms of it, I should say. Yeah.
I'm sorry, I missed that.
Or at the very least, change the terms of a guardianship.
Well, again, I think that the law as written and as it exists provides significant safeguards against these things. And when there are abuses, there are remedies. And I could, I don't know, Dr. Payon, have you been represented by counsel in these cases?
We've had some situations where we were pro se and some where we were represented. When we were represented, we were heard. When we were pro se, we were not allowed to speak.
Well, that unfortunately is not uncommon. But all that means is that you need counsel, and there's no question that counsel is important in all of these cases, not just for the incapacitated person, but also for other interested parties. And in my view, if counsel who's been appointed by the court hasn't done its vigorous, zealous advocacy, then they're guilty of legal malpractice and they should be sued. And if agencies are, not providing the least restrictive alternative in these cases, then there are remedies under various statutes that are out there, like the Americans with Disabilities Act. And so good counsel is part of the problem in the current system. There are not a lot of good counsel that are representing their clients zealously and vigorously. And unless that happens, the courts are not going to, listen to the arguments. They're going to do what they think is best, and that they all strive to do what is legally required. And if the person needs some protection, unfortunately, it is my experience that they err on the side of overprotection, but that can be addressed again through what are called review hearings. And what is required is evidence has to be put before the court, like in any other case, establishing the need for guardianship and what level of guardianship is needed. But counsel is essential in most cases.
And that brings me to actually a question that I have for you, Senator. I mean, your bill at its core really tries to make guardianship a last resort. So I'm wondering if all of you, actually, I'm starting with you, Senator, could talk about some of the alternatives that exist and how to get courts to maybe consider those more closely before attempting a guardianship.
Yeah, thanks so much. And I just do want to share that our legislation is going to attempt to address some of the exit issues. So I don't want people to leave this call thinking that there are not exit issues that can be addressed. And our legislation will attempt to address some of the exit issues that we heard when we got testimony from individuals. So we believe that part of the system can also be improved. In terms of least restrictive, so, where most people want is a family member. Not most people, a lot of people want family member. And we, in the legislation, are trying to, I don't know if I call, there's already a certain level of preference for family member, but we really want to strengthen the family member preference and make it somewhat more challenging for judges to go away from a family member when they look at the appointment determination. So so I think that's our core framework. Now, it is true that the current system with the least restrictive approach does potentially favor family members, but we think we can do more to do that. This will not eliminate the dispute amongst family members. I've been a lawyer for 35 years and very familiar with disputes among family members on all kinds of issues. So I don't want to give the impression that the disputes among family members are going to be resolved merely with this legislation. And in the end, it will be a decision by a Pennsylvania judge on what to do. It's not like there's going to be some other mysterious person who's going to jump into this framework and make the decisions. And so we know this system is dependent upon judges. I do believe that the more we can bring advice to the judges, the better. Strong lawyers helps in the process, but it's also very clear not enough lawyers who do this kind of work in a very experienced and professional way. So I do want the folks to know that this is a national problem is true. That we can do something about it in Pennsylvania is also true. And I very much believe that our legislation, and particularly once we add the exit provisions on, will be a step forward. Will it be everything that we need? No, but I do believe it will be a step forward, and I hope we can get to the support of individuals.
Thanks, Senator. I have two quick questions before we turn to audience questions. The first one is for you, Stephen. The second one will be for you, Dr. Paone. The first one is, what can people do ahead of time while they are still well to avoid a situation where they can end up under guardianship? Specific things like power of attorney, if you can maybe expound a little bit on that.
So, there is ample opportunity to do advanced planning to avoid guardianship. It's never perfect because you can appoint. So when we talk about first powers of attorney, because powers of attorney is probably the primary tool today to for an individual to plan ahead, to have his affairs taken care of, both personally and over their property, to avoid guardianship. And it's a flexible tool because you're authorizing a third party to take over when you are unable to take over, and to take over only to the extent that is necessary. But even with that kind of tool, which I would recommend that everybody consider as part of their planning process, if you write a will, you should consider a power of attorney. It's not perfect because you could appoint a child as your agent under a power of attorney, and your child could abuse the power of attorney and breach the fiduciary duty towards their principal, and favor themselves over their other siblings, for example, which happens all the time. So no system's perfect, but if you have planned ahead and you've done the best you can, you're most likely going to avoid guardianship in a family which is at least functional. When there's dysfunction, there's always going to be problems.
Dr. Paone, I wanted to ask you, as somebody who has had the kind of experience that you've had, if you can just talk a little bit about the emotional stress and impact that this has on life when you're dealing with it.
Of course, and that is definitely right up my alley as a professional counselor. Most folks, and including ourselves, we feel powerless. We're unheard, we're unrecognized, invalidated, disregarded in the worst ways. I am listening on the panel. I appreciate what Senator Haywood is talking about, adding those exits. There are folks that are never going to exit guardianship. My mom is one of them. She is not going to exit guardianship. It is, how do we get those professional folks out? when they are not necessary, when they are actually impeding or creating the abuse that's happening. So I understand the entrance, and I understand, in cases where folks have gained capacity back, and when we look for those least restrictive ways, but there are some cases, as I said, my mother's specifically, she will never come out of guardianship. She is incapacitated to the fullest extent. She cannot take care of her daily needs. We need to do all of those things for her. So when you are working with the court system and they have appointed these players or these professionals or whatever you want to call them, and they're intertwined in working with each other, you are watching from the background these increased financial bills that she doesn't need or that other folks don't need. I know that, Steve, you spoke about folks getting their stuff situated prior to, and I hear you, but not every person out there has a power of attorney. They don't have these wills put together. A lot of folks don't do that. Majority of our citizens in the United States, particularly in Pennsylvania, we don't have the finances to put these things together. And anything that is not documented by a represented attorney, it gets thrown out. And I think you've been reading in the chat, folks are putting that up all over. Those power of attorneys, those living wills, those advanced directives, judges are ignoring those things because whatever they've decided is superseding those things. So even when a person has their capacities, they make decisions and then they're ignored. That's why we feel powerless. We feel like there is nothing we can do for our loved one. Again, you're reading in the chat, people are not even permitted to see their parents. I mean, that's really difficult for anyone to say, oh, you can no longer see your mother. You can no longer see your father because I, judge, have decided you can't. And I know you see it from a different perspective, and I hear victim stories all the time. And, again, as a professional counselor, I hear the emotion coming through. I would, definitely empathize with all of those folks who experience that powerlessness and that victimization as someone who is dealing with someone else's victimization. It's not mine, it's my mother's. It's not me, it is her. I'm watching her being taken advantage of as a marginalized person.
Thank you, Dr. Paone. I wanted to turn to some audience questions now, and I want to thank everybody who submitted those. There are some really great ones. One that came in is, how exactly is guardianship overseen by the Pennsylvania Department of Aging, and where do county area agencies on aging fall into that rubric? And that came from Steve L., Annie G., Lynn M., and Edward H. And I guess, Stephen, do you want to try and tackle that one?
Sure. So as I think I mentioned it, at least I mentioned it to you maybe before we went on live. There's another system of surrogate decision-making in Pennsylvania, and it's called the Older Adults Protective Services Act. And that act is administered under the Department of Aging, supervising the area agencies on aging, which provide the services on a county-by-county basis. And there are an extensive set of rules, statutory and regulatory, which govern the way the AAA, the Area Agency on Aging, is supposed to administer the law in providing services in the least restrictive manner, in the most integrated setting, in their own home or in the community somewhere, and to take into consideration the individual's desires and input to the extent possible. And I think, and I know that you mentioned, Senator Haywood, the Byers case. It's been a long time for me when I looked at this stuff, but I think the Byers case was cases that came to her through the Area Agency on Aging, if I'm not mistaken. I could be, but I'm not sure. And in those cases, the Area Agency on Aging is, I think, very vulnerable to being sued. And again, they are required to have counsel appointed for the individual if the individual doesn't agree to have services provided. I think that they have to provide counsel and provide services in the least restrictive manner possible. And if that's not happening, they're violating the mandate, which would make them vulnerable to a lawsuit. And I would encourage anybody who is experiencing these kinds of problems to contact an attorney and discuss it with them and what can be done. Because there's really no reason for any of that.
Yeah, you touched on something, the same group of people had a follow-up question, which was, what procedures or policies are in place to ensure that the attorney assigned to the person who might be deemed incapacitated is prepared and fully understands the protective services case that prompted the petition. And to sort of paraphrase, I mean, I guess what I'm in some respects, this question goes to the heart of like, what kind of oversight really is there, these area agencies on aging and the work that they do.
Well, they're supposed to be supervised by the Department of Aging. Again, if they are going to court to have a guardian appointed, they are still required to comply with their statute and their mandate. And, it's not entirely clear to me that the courts are forcing them to. I think some of the judicial districts are better at applying the law than other judicial districts. But again, there's remedies available. And there's all kinds of federal remedies. You could take some of the AAAs to federal court, where a federal judge will sit over the case in an appropriate case.
There's a question from Jenny, and I'm going to throw this one to you, Senator. The guardianship system is subject to almost no checks and balances. Can we implement a task force similar to that in New Jersey, where these people are held accountable and have ramifications for dereliction of duty?
So thanks so much for that question. And I do want to share my profound regret for all those who have suffered from the system, including Dr. Payola, but all the people in the chat. Obviously, something serious is going wrong here. Number two, for most of the guardianship cases, the area offices for aging are not, outside of the protection cases, this is a court-based system. It's a court-based system where the top is the Supreme Court, and then the county judges make the decision. So we have a court-based system. The accountability is amongst litigants, as Steve has described, and the top level is the Supreme Court. So the courts are the core for decision-making, which is part of the limitations of having to get a lawyer to get a resolution, because it's a court-based system. But it is, so just for people, the oversight, top level of Supreme Court, Pennsylvania. In terms of the task force, I think we could possibly put together a task force in Pennsylvania. Our first step is to get this legislation passed, which will help deal with entry and exit. That's what we're trying to do now. My experience with task forces, they can be good. They come up with recommendations. They typically, those recommendations have to be adopted by the General Assembly. It's not like the task force has independent power. So I think that's something we could look at, but I think for the short term, if we're looking for answers in the next 12 months, the legislation we have on the table is primary. If we're looking for solutions, task force usually 24, 36 months or more before there's a solution that comes out of them, but still high value.
Okay, and there's another question from Jenny. It involves the guardianship tracking system, and I'm going to throw it out to any one of you who's had experience with that. The guardianship tracking system and the annual reports are lacking in pertinent information and oversight. Who is responsible for making these more robust going forward and making sure they contain at least minimally required information? Who wants to tackle that one first? I guess I'm going to throw it to you, Stephen.
Oh.
Then you, Dr. Peo. Okay.
Like I told you before we started, I don't have a whole lot of experience in the tracking system because I often don't take on guardianship cases. The Pennsylvania Supreme Court would be responsible for making it more robust. They generally do that in consultation with, the entire, judicial system from the top to the bottom. They get input from the bar and from the community, and I'm sure, and I'm told that they're going to be making some dramatic improvements in the tracking system. But like I said, I'm not really that experienced with it myself.
Okay. Dr. Payon?
Sure. My experience is that the guardianship system, tracking system came into play in 2018 is where we implemented it in the state of Pennsylvania. Prior to that, there was a report system. It wasn't electronic. So now it is electronic. It is drop down. You do fill in the blanks essentially for your loved one, depending on your role. And then it goes to your judge of record. It goes as an entry on the docket that it's there. It can be viewed by the judge, the court appointed attorney. It is understood through the bench book that it is your judge that should be reviewing those components along with the interested parties in those cases. As far as robust, it is not that it is not robust, it is that no one's checking what's going into it. So when you do not file a report, the guardianship tracking system will spit out a late notice, and that will go to your judge of record. According to Pennsylvania law, that is supposed to be something that the judge does address. And in my small amount of research, I can see that judges will address that in certain cases, depending on who the guardian is, but will not address it in all cases. So a first guardianship late notice goes out, a second guardianship late notice goes out, and then a guardian can submit a document. One of the issues with the guardianship tracking system is that everyone's putting this information in, but there is no one doing anything with it coming out. So when we look at collecting data from a research standpoint, it should be spitting out flags when something looks weird. For example, if I am a guardian of the estate and I'm putting in a net worth of $1 million, but I never change it despite the fact that an incapacitated person is using their money, there's a problem there, and the system should flag it. It is not flagging those type of things now. So we have the data. No one is pulling it, and it is certainly inaccessible to most folks. If you are a guardian, you can access it. If you're a family member and not a guardian, you cannot access it unless it is sent to you. That seems to be a problem with the system, and it's there. We have the technology. We're just not using it.
Yeah, you anticipated my question. If you're just a member of the public and you're trying to pull some data from that, is there anything that's available to you? Whether you're a family member or not, just a member of the public.
If you read through the docket and you literally go through case by case, you can see which families have had late guardianship tracking systems, which ones submit their reports, when are they timely, because in an individual's list of docket items, you'll see submitted report, or late report. Anyone can see that. You can see it, I can see it, and I can see it on everyone's case. But who has the time to go through everyone's case? Like, that isn't where we're going. I look at my mom's case because that's important to me. But if you're looking from a grand or a larger scale, that should be something, or data from a general standpoint, that we should be able to extract, or at least that a report is publicly made available. How many folks are being, reported on each calendar year, and how many are submitted on time, how many are submitted late, who is being held accountable when reports are submitted late, where are the problems coming up? These are, as Steve had said earlier, we can see this stuff. It is very transparent. So why aren't we doing anything about it? Or why is that not available to us?
Stephen, I've seen a lot of this in the chat as we've been talking about it. And do you have any advice for people who are on tight budgets, maybe cannot afford a lawyer, on if they are experiencing issues either with the professional guardian or a court-appointed lawyer? What can they do to help
So-
themselves if they don't have enough money to hire their own private lawyer?
So, the Senior Law Center has a guardianship advocacy project for, advocating on behalf of the older individual, not necessarily a family member, but it could be brought to the court's attention that there may be a need to get, attorney appointed. And a lot of remedies are fee generating. For example, if a lawyer is representing an alleged incapacitated person and not doing a very good job of it and is deviating from the standard of what is expected, that lawyer can be sued for legal malpractice, and the damage award is the fee generating. The lawyer, like in most personal injury actions, there's a measure of damages, and the lawyer, can be paid, a contingent fee if he prevails. For more serious violations of the laws, and again, I'm staying away from the guardianship stuff because they could be sued for violating their fiduciary duty. Again, that can be fee generating. That's generally not, because you're recovering from a person's estate. That's usually on an hourly basis. But if a person's imposed with a guardianship when it's not necessary, it's my opinion that there are, like I said, there's like action under the Americans with Disabilities Act. If their due process rights have been violated, there's a 1983 action under federal law. Both of those actions are fee generating. If the plaintiff prevails, they are entitled to be paid. So if the Area Agency on Aging is not doing their job, they can be forced to pay.
And this is unfortunately, we are running up against time, but I'm going to try and squeeze in one more question. And Senator, I'll push that one to you. We've gotten several questions about whether there are better ways to handle cases in which family members are at odds over the best direction of care for an incapacitated individual. Should judges do more to work through that before turning to a professional guardian? Or is the court system just so overwhelmed that there isn't really, I guess, the funding or the time to do that kind of work? And is it something that could even be legislated?
So judges will continue to make the decisions on the appropriateness or lack of appropriateness of a guardian, as well as supported decision-making. I saw that was one of the provisions, solutions that people recommended. Those decisions will be in the hands of a judge. That's our system. Now, we can do some things to make it more likely that a family member will be selected. We're looking at that in our legislation. But in the end, it will be a judge who makes that decision. So I know there are a lot of complaints in the chat about the judges and what they're doing and what they're not doing. Some are thorough, some are not thorough. We got several hundred judges in the Commonwealth. So I think we should try to continue to work for some higher standard, some uniformity. Angela, as you know, we have had an unfortunate case of cash for kids in the Commonwealth, so we have had some challenges. My experience with judges is that they take their jobs very seriously. But to the extent we've got any kind of collusion going on between judges, court-appointed judges, those who are managing money, I mean, that requires a significant investigation that from this conversation and others we've had seem warranted that we look closely at it. But it's a serious allegation that would require a tremendous amount of investigation. Yes.
No doubt. As much as I'd like to continue this conversation for another hour, maybe more, I want to be respectful of everybody's time. I want to thank our panelists. It's been a really interesting discussion. I think actually through disagreements and listening to each other, there's a lot of value in that. And so I want to thank you, Senator Haywood, Dr. Paone, and Stephen Feldman, very, very much for doing this today. You can find more of our events on our website, www.spotlightpa.org/events. And as I said at the outset, if I did not get to your question today, please feel free to reach out to me via email. You can call me. All of my information is on the Spotlight website. Again, thank you very much. And I look forward to doing more reporting and speaking to all of you in the future.
Thank you.
Thank you.
Thank you.